right, thank you very much, Les. Yes, I came to the title business from private practice just about 2 years ago, so a relative newcomer to the industry, and I'm finding this phase I'm in right now to be the conference speaker phase. So they let me relax for about 16 months or so, and then the requests started coming in. But I'm happy to do it, and I hope I don't bore you too much. My job today is to give you a case law review, which apparently is one of my duties as the chair of the Judicial Committee for the Land Title Association. So this year, let's see if we make this go. I didn't find a lot of compelling Idaho cases, so the main focus of my presentation is going to be Brandt versus United States, which is a Supreme Court case having to do with what happens to a railway after the railroad has abandoned the property. Is this one working, or can you only hear me when I go here? Okay, I'll just try and stick close to the mic. Secondly, I'll look at an Idaho decision from 2016 regarding competing security interests, 2 deeds of trust, and a priority fight. Finally, a wrongful foreclosure action, Hout versus Wells Fargo Bank. I'm not sure how you pronounce that name. I've been calling it Hout, and I'll probably just refer to them as the borrower in the case. Also, my email address is here. In case you find the slides interesting, you're welcome to send me an email, and I will send you a copy. Okay, so Brandt versus United States was actually decided in 2014. I don't think we've covered it at a land title conference meeting in Idaho, so we kind of agreed this would be a good one to go over this year. And an overview of the case is that a railroad company abandoned a railroad right-of-way that was granted in 1908, federally granted right-of-way, which they sometimes refer to as FGROs. After that abandonment, the United States sought an order quieting title to that property in the United States. And one of the landowners involved contested the matter, arguing that that he now owned the fee himself. So the arguments that they put forth respectively are that the landowner argued that this grant of a right-of-way granted only an easement. Therefore, under the common law, when the railroad stopped using the easement for its intended purpose, the easement was extinguished and went away. So the land he had acquired then simply became unburdened by that easement. The United States, of course, thought differently, argued that, well, those federally granted rights of way granted a limited fee, and the government retained some kind of reversionary interest, specifically a future interest, whereby title would be restored to the United States if the railroad abandoned the property. So I'm going to have to suffer for you some of the facts of this case, given the time I've been allotted here. The history of the railway itself was that in 1908, the United States granted the right-of-way to the Laramie, Hans Peak, and Pacific Railway Company for development of a railroad. That company completed construction of this railroad in 1911, and it stretched from Laramie, Wyoming, southwest to Colmont, Colorado, which is actually pretty near Steamboat Springs, Colorado, just over the Rabbit Ears Pass from Steamboat. And ultimately, it was 66 miles long on a 200-foot wide right-of-way. And actually, that 66-mile portion was the portion that was in Wyoming. The Colorado share of the right-of-way was not at issue in the case. And this railway had been envisioned as a means to transport coal and other valuable minerals, but that didn't pan out for the developers of the railway, and it ended up being used for timber and cattle. This led to lots of change in ownership in the railway from 1908 to 1935 when the Union Pacific finally acquired it. Okay, the Brandts, the plaintiffs in this case, the appellants, they'll be the ones who bring the appeal. They acquired their parcel by a grant, a patent from the United States in 1976. So the Brandts had settled there in 1939, started a sawmill, eventually were able to get this patent to an 83-acre parcel in Fox Park, Wyoming. So Marvin and Lulu Brandt then eventually transferred the land into their trust, which is why it's the Brandt Revocable Trust bringing the action. Okay, so moving on with the facts to the abandonment of the right-of-way, or the railway. Got ahead of myself here. So in 1987, the Union Pacific finally decided they had no use for this rail line, and they sold it to another railroad company, the Wyoming and Colorado Railroad, who decided they would operate it as a tourist attraction. And by 1996, that venture had proven financially not viable as well. So in 1996, that railroad filed a notice of intent to abandon with the Surface Transportation Board, which was accepted. And by 2004, they had removed all tracks and ties from this 200-foot wide, 66-mile stretch of right-of-way. So the United States actually initiated the litigation seeking to quiet title to the right-of-way. There were 31 landowners along this 66-mile stretch, and the United States managed to settle or obtain default judgments against all but one of the landowners, 30 of the 31. So Brandt, as the trustee of this family trust, filed a counterclaim seeking the declaration that he owned the title without the burden of the easement. So Brandt ended up losing in the district court in Wyoming and in a federal appellate court. The federal appellate court agreed with the government's contention that, well, it was a limited fee that was granted, not an easement, a limited fee with a reversionary interest. And in reaching that decision, they had acknowledged that there was a split among the circuits. So they had to pick one of the cases and move forward. We'll get to the history of some of the cases in a moment. All right, so when we're looking at railroad grants of rights of way, we always have to look at which act they were passed under, and this is kind of a history of the acts. An 1852 act authorized granting railroads a 100-foot right-of-way across public lands. And then by 1962, they started what they called the checkerboard era. And in order to promote expansion of the railway across the West and encourage these companies to build the railways, they started granting not only the rights of way, but fee ownership in alternating sections, 20 miles or so on either side of the railway, with the idea that these railroad companies would sell this land to finance construction of the railway. So by 1875, everyone was unhappy with that practice, feeling that these railroads, the robber barons as they were known, were getting all of this land for free. They were selling some of it, they were holding on to some of it. It was just a windfall to the landowners. So they passed this act in 1875 that discontinued this checkerboard grant and allowed grants of 200-foot rights of way. This will be the act that the Brandt parcel was given under. All right, so since we're looking at all these 150-year-old dates, we're going to have a history quiz and an opportunity to win either a coffee mug or a reading light, one of those coiled up reading lights that you can clip onto your bedstand. So if these questions are too hard, I'll just make them easier. But I'll just I'll look for a show of hands. And the first question is, in what year was the final golden spike of the Transcontinental Railroad set?
1849.
Nope. Close. How about, does anyone know who drove that spike? No? Where is that spike located? Oh, here, Taylor?
Promontory, Utah.
Promontory Summit, Utah. Correct. So, it was set May 10, 1869, and it was actually driven by Leland Stanford, who was a known robber baron and the founder of Stanford University. Taylor, I won't make you get up if you don't want to, but help yourself to a light or a mug. All right, question number 2. Since we're approaching Idaho History Day, in what year was Idaho made a U.S. territory?
1863.
That's right. And it was made a territory actually on March 4, 1863. So tomorrow will be the 153rd anniversary of that date. Easier question. What president signed the act that made Idaho a U.S. territory? Lincoln. Paul, is that you? Oh. All right, we'll have more fun later. Back to our case. All right, so as a result of this Wyoming Circuit Court's decision, it created a split, or a further split, in the federal courts as to what happens to these right-of-ways when they're abandoned by a railroad. And particularly Hash versus United States was a 2005 case, which held that the rights-of-way were, under this 1875 Act, where the Brandts got their property, were only easements. And that court stated that, look, if the government did not reserve a servient fee in a subsequent patent of adjoining land, they could not retake possession and convert the right-of-way into a public trail system, despite a federal statute authorizing such conversion. So the Rails to Trails Act had been passed, and in this dispute, the government sided with the patent holder or its successor. Okay, and then the Brandt Trust decision, which was appealed, as I said, was the government had retained a reversionary interest, and the court declared that, set the precedent that all rights-of-way granted under this 1875 Act would be subject to this reversionary interest in the United States. So, Brandt decided to try his luck with the Supreme Court, and the government actually supported his petition for certiorari in hopes of having the court endorse this Brandt Trust decision and do away with Hash and its predecessors. Does anyone know what a petition for certiorari is? Coffee mug, anyone? So when you appeal to the Supreme Court, you have to convince the Supreme Court to take and hear the case. So when someone appeals to the Supreme Court, your paperwork includes a petition for certiorari that says, here's why you need to make this policy decision. This is why, you can't appeal your speeding ticket up to the Supreme Court. They get thousands of cases a year, and they take about 100. Okay, so the Supreme Court is now going to look at this Brandt decision and the conflict we have in the existing law. And they decided that the government's own arguments in a case 70 years earlier decided the issue in favor of the landowner. And that case was Great Northern Railway versus United States in 1942. So in this case, the railroad company, with its right-of-way, discovered valuable minerals, actually oil, beneath the right-of-way. And it was their intent to extract oil from the ground beneath their right-of-way. So under this limited fee concept with a reverter, they asserted that they could do that. The government filed a suit to stop them from extracting this oil and argued that, in contrast to the prior acts, the 1875 Act granted only an easement, not some type of fee with a reverter to the government. So, back in 1942, the Supreme Court sided with the government, said you're correct, this 1875 Act is different. Recall that it was granted when we're trying to withdraw from the checkerboard approach, and we're trying to withdraw from what we're actually giving to these railways. And that was the argument the government made, and they prevailed. And so the rail company had only an easement, could not extract the oil. And this concept was supported by the patent itself. If you take a look at the Brandt patent, it stated that the land was subject to those rights for railroad purposes as have been granted to the Laramie, Hans, Peak, and Pacific Railway Company, its successors or assigns. It said nothing about being subject to any reversionary interest or other interest in the government, despite numerous reservations in the patent like you normally see. So the court said, you were right the first time, government, you can't change your mind now and argue that this is a fee, a limited fee with a reverter interest. The grant to the railway was an easement, not a limited fee. And all railroad rights-of-way granted under this 1875 Act are treated as easements upon abandonment. The underlying fee is owned by the patentees and their successors. So upon abandonment, the easement is simply extinguished and goes away. Government has no reversionary interest. So, title implications. It's a windfall to patent holders and their successors if a railway abandons a right-of-way that crosses their land. And it disrupted this Rails to Trails Act. I'm not sure how it's going to play out, whether or not they're going to have to revisit that act and add some strength to it. But as the law stands now, without a specific reservation by the government in a patent, it's simply an easement that goes away when the railroad abandons. So, I'm sure all the underwriters in the room would agree that when it comes to these railroad issues, we encourage you to give us a call. In cases where the finality of the abandonment is in question at all, we must take exceptions for any potential reversionary interest in the government and any failure to follow procedure in the abandonment process. So the railroad can't just pull up its tracks and be done with it. There is a process with the Surface Transportation Board. So that's the Brandt decision. Any questions? I'm probably way over my time already. Oh no, I'm not doing too bad. Okay, let's have another history quiz. I was inspired to do this because on the news the other day I saw that tomorrow is Idaho History Day. And I, of course, drilled my kids a little bit, and hopefully they'll raise their hand and get a question right. In what year was Idaho admitted to the Union as a state? 1890. I don't know who got that right. There you go. July 3rd, 1890. Under what president was Idaho admitted as a state? That's a pretty hard one. Anyone's favorite president? Benjamin Harrison? But it's worth noting that Grover Cleveland, who was both Benjamin Harrison's predecessor and successor, he saved Idaho by refusing to sign a bill that would have dissolved the Idaho Territory before it became a state and split it up into Washington and Nevada at the time. Okay, one more shot here. Of the 50 states, what number is Idaho? You got it. Okay, I'm over the scheduled time, but I'm not over my allotted time, and it's not like I have a big desire to stay up here. But I will quickly go through the Idaho cases unless the next presenter is anxious to get started or if we're concerned about being off time. Should I move forward, Les? Or? All right, all right. Say it again. Oh, okay. Okay, two Idaho decisions. First is Liberty v. Witherspoon. Most of you have probably heard of Witherspoon Kelly, a firm up in Spokane with an office in Coeur d'Alene and possibly other places. In my experience, a good law firm with good people. So, in this particular case, the law firm had assisted a developer in acquiring a tract of land in Post Falls. It was going to be the point at Post Falls, a big development on the river. And so when they finally closed the deal, as payment for the services the law firm had given, the developer gave the law firm a note and a deed of trust. I see some of you smiling. Maybe you're involved in this case. But so after that, the developer, of course, went out and got a development loan to build all the facilities and had its own deed of trust. So I'll give you the timeline. So it acquired the parcel in September 2001. Witherspoon Kelly's deed of trust recorded in October 2004. And then August 26, 2005 was the first of the development loans, the $3.9 million deed of trust in favor of Liberty Life Bankers Insurance Company. And the firm signed a subordination agreement to go along with that deed of trust, to consent to that deed of trust having priority. August 2010, the law firm recorded a modification of their deed of trust, which added a marina property as security, and they recorded a UCC1 with respect to the marina property. Then, so meanwhile, there were 6 modifications of the Liberty loan, and in each case, the firm had signed a subordination agreement. September 2010, 7th modification agreement is recorded with Liberty Bankers. And they increased their principal balance to $9.3 million and extended the maturity date. Once again, the firm signs a subordination agreement. August 2011, Liberty records a notice of default on its deed of trust, which presumably at that time would have had priority over the firm's deed of trust. But in September of 2011, they entered into another loan modification agreement where the lender agreed to release 3 blocks from the original deed of trust, and the developer would execute a new note and deed of trust for a new loan separate and apart from the existing loan. However, they never recorded this loan modification agreement. They never recorded the deed of trust or the release of the 3 lots. So, in lieu of recording those documents and plowing forward with this development, it ended up that Liberty just went ahead with their foreclosure, and they got a trustee's deed for the property. So, to resolve issues that the law firm was asserting, Liberty sued for a declaration that its title under the trustee's deed, including the title to the 3 blocks, were free and clear of a security interest of the firm, and that the marina property was a fixture and therefore conveyed by trustee's deed free and clear of any interest of the law firm. And the firm, of course, asserted the opposite. They asserted that this 8th modification agreement released these 3 blocks even if it wasn't recorded, and that the marina improvements were personal property subject to their UCC security interest. Okay, so the first issue is, did the deed of trust, or the trustee's deed, convey the 3 blocks free and clear of Witherspoon Kelly's deed of trust? The lower court decided that no, they did not. The 8th loan modification agreement had the effect of releasing the 3 blocks and securing them under that new deed of trust, even though it wasn't recorded. They cited Idaho 45-108, which states that a lien may be created simply by contract. And they had to finesse it a little bit to decide that, well, the foreclosure still occurred, but as to those 3 blocks, it occurred under that second deed of trust, which was subordinate to the firm's deed of trust. So that deed, the firm's deed of trust would still encumber those 3 blocks. The Idaho Supreme Court reversed that decision and said, yes, the trustee did convey these 3 blocks free and clear of the firm's interest. 45-108 does not apply to the interest conveyed by a deed of trust. It applies to other types of liens, but not the deed of trust. Wasn't recorded, had no effect. The property couldn't have been sold under that second deed of trust because it wasn't recorded. All right, second issue for the firm now is, can I establish that the marina and its improvements are personal property and therefore still subject to our lien, not cleared by this trustee's sale? The marina itself was 142 boat slips, a floating convenience store, and fuel pumps. It's connected to the real property by a ramp through gas and electrical lines. And it was built specifically for this project, but designed to pull apart and unplug to be used elsewhere if necessary. And that if necessary being if the developer was unable to get the appropriate permits from the Department of Lands. So a question that comes up pretty often is whether or not a particular article is a fixture or personal property. And so the Supreme Court set out the standard, annexation to the realty, adaptation to the use of the particular property, intent of the parties to make it a permanent accession to the freehold. So the district court decided it's personal property. So once again, they appear to be trying to help out the local firm and say, we got to save some kind of security interest for these guys. And the court reasoned that the marina was attached to the land and intended a part of the overall development, but the intent of the developer was that it could be detachable, which demonstrates to the lower court anyways that it's personal property. The Supreme Court said no, the district court has placed too much emphasis on the intent of the developer and should have focused on the more objective facts as to each article within the marina. So, impact of this case is that a marina, a dock, related improvements may constitute a fixture and therefore be considered real property. All right, last case. I've been calling it Hote v. Wells Fargo. So, in this case, fairly typical, a foreclosed out borrower brought a lawsuit against both the lender and the trustee, asserting wrongful foreclosure. Facts aren't particularly important in this case. So prior to the sale occurring, these borrowers filed a suit to enjoin the sale, to recover damages from the lender, and to recover damages from the trustee on the ground that Wells Fargo was not the beneficiary of record at the time the notice of default and sale was recorded. So, as to enjoining the sale, the borrower lost because Wells Fargo put forth two arguments. First, that it was a merger under this federal statute, therefore we're basically the same party as the initially named beneficiary. We don't need to record an assignment. Secondly, during the litigation, they just went out and got the assignment. So they lost on their request for an injunction. But they were allowed to go forward with their claim for damages for wrongful foreclosure. And they agreed to just sell the property. They stipulated to a sale with the proceeds tendered to the court in case any of those proceeds would go back to the borrower as a part of this wrongful foreclosure claim. But in Idaho, there's not a separate claim for wrongful foreclosure as there is in other states. It has to be treated as a cause of action for conversion. And a cause of action for conversion of someone else's property doesn't occur until you actually take the property from them. So the Supreme Court decided that the trustee sale never occurred. You stipulated to the sale. There's no claim for conversion, no claim for damages against the lender. I'm on the claim 3 already. So this is the claim against the trustee. They went to the trustee and said, you filed a notice of default and notice of sale under this deed of trust, even though you weren't instructed to do so by the beneficiary of record, because Wells Fargo wasn't the beneficiary at the time. And the court basically said, the trustee doesn't have to go verify that they have the right party. The statute says, that the deed of trust must be recorded, but it does not say that the trustee must go out and verify that they've got the right party. So that claim, and additionally, once again, the borrower had consented to this stipulated sale, so it was moot by that point. So that's Hote. Any questions on that case? All right, that's all I have. Thank you.